He had an inability to discuss with any sort of sophistication the legal process, what everyone's roles were.
A Siders family member rushed to the hospital, questions about his mental state swirling, as prosecutors bring in reinforcements to investigate and take these child endangerment cases to trial.
Both of these women are outstanding prosecutors with extensive experience in child cases.
Plus, the mother of the sixth.
The Vinton County grand jury indictment, unsealed at 4:37 p.m. yesterday, reads as follows: Count 1, endangering children, a felony of the third degree, alleging that the defendant did create a substantial risk to the health or safety of a child by violating a duty of care. It is the word substantial that does all the work here, a legal term that translates plainly to something the statute cannot bring itself to say the children in that house were surviving in conditions the state had not witnessed since the era of poor farms. Imagine a single family home with 16 children, where the bathtub was used not for bathing but for storing buckets of rainwater, because the water had been shut off for 11 months. That image, a porcelain tub full of stagnant water reflecting a ceiling stained the color of tobacco, is not poetic license. It comes directly from the property maintenance log entered into evidence, Exhibit 23. That house was a lung slowly filling with fluid, and no one outside those walls was listening to it breathe.
Gary Jr. and Elizabeth have so many children when prosecutors say they couldn't take care of them properly. I told you earlier this week that Elizabeth and Gary Jr. were married in March of 2008 in West Virginia. Elizabeth was just 15 and Gary Jr. was 18. They had a child a short time after they were married, and then more children came after that, including 2 premature twins who died shortly after they were born in November.
Before we go deeper into what the documents actually show, make sure you are subscribed to Endless Cryme, because we do not just cover the story, we follow the evidence. The prosecutors, county and state both, held a press conference on July 5th in which they described a coordinated law enforcement response, a search warrant executed with precision, and an immediate medical evacuation of the minors. What they did not describe, what the indictment does not mention, is that the Vinton County Children's Services Division had an open file on this address dating back to 2019. A file that was closed 6 months later with a handwritten notation: family relocated. Unable to locate, they relocated 4 miles away to the R Street property. The system saw them only on paper. That was the first time.
County near Vinton once visited Gary Jr. and Elizabeth Siders. And then the couple moved with their children, I'm told, to avoid social workers, fearing their children would be taken away from them. The Attorney General said they were basically hiding these children.
Now the new explosive detail sits in a motion filed by the mother's attorney just this week, a motion that accidentally reveals more than it intends. In arguing for a bond reduction, the defense attached a character letter from a former neighbor in the town of MacArthur, a woman who states that she once called the sheriff's office in 2021 to report that children in the Siders household were always hungry, always asking for food, at her back door. The Vinton County Sheriff's Incident Report confirms a deputy was dispatched. The deputy's narrative, which we obtained through a public records request, reads, made contact with Mrs. Elizabeth Siders, who stated everything was fine. Observed several juveniles in the yard. Appeared normal. No further action taken. The deputy never entered the home. The deputy never looked past the screen door. The system saw them only on paper. That was the second time.
Elizabeth's brother wrote on social media on July 7th, "This is what I think. Slap on the wrist. You cannot be charged for ignorance. The horror stories is not true. Nothing is true. My sister and her husband really did do the best to their IQ. Allowance is the one to blame. Low IQ, getting that money, similar, just like me, only on plus 500 app. I be chasing that money with a bit higher IQ. Everything is misunderstood. Their hygiene, low IQ. The man of the house is responsible at most. He is the leader, leading."
Here the narrative splits like a cracked foundation. On one side, you have the official timeline, a routine warrant service on June 30th that uncovered a nightmare no one could have predicted. On the other side, you have a parallel history, a shadow docket of near misses. A 2019 caseworker visit prompted by a hospital report of malnutrition in one of the infants, closed because the family moved. A 2021 sheriff's call closed from the front porch. A 2022 emergency room mission for a child with severe dental abscesses that triggered a mandatory reporter notification to the Ohio Department of Job and Family Services, which triggered an inter-county referral that vanished when the family's address was flagged as transient. The county line became a firewall. Each time the warning flare went up, a piece of paper was generated, filed, and then forgotten by everyone except the children. And then comes the ticking clock moment, the hinge where this ceases to be a local crime story and becomes a national security failure of a different kind, a failure of the social immune system. So the question must be asked if an 18-year-old mother, pregnant for the third time, with no high school diploma, no driver's license, and no visible means of support can disappear 16 children inside a quiet Ohio county without any state agency ever assembling the full picture, then how many more houses are operating right now under the same legal invisibility cloak? Their addresses passed from one overworked caseworker to the next like a hot potato no one wants to hold. The moral architecture of this case is now being assembled by lawyers who speak a language designed to blunt horror. Gary Siders Sr.'s competency motion argues that the 73-year-old cannot assist in his own defense because he exhibits an inability to discuss the legal process with any sophistication.
Significant confusion about the legal process, was unable to describe the specific roles of the various participants in the court proceedings, including even the role of counsel to aid in his legal defense, and was unable to describe even basic facts about himself. The defendant was generally unable to maintain a clear and consistent train of thought throughout the interaction and was clearly struggling to understand what is going on. The defendant's conduct leads counsel to believe that the defendant may be suffering from significant mental health issues and that competency may be an issue and clear impediment in the defendant's ability to aid in his own defense. Collateral information has seemed to confirm that the defendant suffers from significant health issues, including a decline in mental function and functionality, which would be consistent with counsel's observation of the defendant, both during his interactions with the court and with counsel.
That is a quote from the motion.
He obviously understood a person greeting him, but again, as I noted in my motion, he definitely had some confusion about the process, about what was going on. He had an inability to discuss with any sort of sophistication the legal process, what everyone's roles were, which again, as I've said in here and elsewhere, competency is a bedrock. It's a bedrock precondition to be able to move forward in any criminal case. And if you don't have that, you just simply can't. I'm going to circle back around to what you already asked also. Is he a danger to the community? I would have suggested he's never been a danger to the community. And certainly in his present condition, he isn't. He is not dangerous. What I would consider him to be is a sad and sympathetic character, primarily because of his general level of confusion and both the mental health and physical issues that I was sort of seeing. And when you asked what I was sort of observing, it was very similar to what we've all seen during the preliminary hearing and his behaviors and mannerisms there, where there was just a general lack of confusion, inability to hear very well, certainly mobility issues, and an inability to sort of in any way.
What the motion cannot do, what no pleading can do, is explain how a man who allegedly could not grasp his own court proceedings was nonetheless listed as the head of household on a Section 8 housing voucher application that required annual recertification of income and occupancy. Forms he signed under penalty of perjury. The forms show 16 dependents. They show 0 income from employment. They show a box checked for physical or mental impairment that limits ability to work for the applicant himself.
I use the term dementia not because I myself am a doctor and I'm diagnosing Mr. Siders, but most people have had some experience meeting a person with dementia. And I think we can all appreciate that a person who has dementia may say something inappropriate. Let's talk about low level, not talk about this case at all, just low level issues. They might say something inappropriate, or they might accidentally lash out. And we all recognize that person. We say things even colloquially. Well, they don't know what they're doing, right? So this is, of course, a more serious matter, but it's also a more serious legal term of art where it's that, but put within the law, right? Mm-hmm. It's, does this person appreciate the wrongfulness of what took place? And if he doesn't, then that is where...
That form is a confession written in bureaucratic ink. The system saw them only on paper. That was the third time.
My career, and maybe this is just because I've never in bad faith made this motion, but I have never had anyone object to an evaluation to see if the defendant is competent, so long as it's made in good faith. This is not an unusual motion to be filed with the court. As I said, it's a bedrock precondition to move forward. Same thing with in that same motion, it's not atypical. In fact, it's a matter of course that I typically file both that and the motion for an evaluation for not guilty by reason of insanity, because they are very similar evaluations. And in just so your viewers know, procedurally speaking, you first have to determine if they're competent. If they're not competent, then of course you have to determine whether they are restorable to competency or not. If they're restorable or potentially restorable, they will send them to a mental health facility for restoration services to see if they can in fact be restored. If they're not restorable, then they are just deemed incompetent. And then the court is left with sort of other questions of how are we going to handle this moving forward with an individual who's not competent. If they are in found to be competent, then they will do the second part of the evaluation, which is, were they legally insane at the time? And again, you do a law show, so I'm sure you understand, but perhaps your viewers don't. Legally insane is not something.
We now know from a supplemental affidavit filed by the Ohio Bureau of Criminal Investigation that investigators have seized 47 boxes of documents from the R Street residence, including homeschool attendance records that appear to have been photocopied from a template, financial ledgers in the grandmother's handwriting tracking exactly how much each child's SNP benefit and SSI payment contributed to the monthly household pool, and a series of notebooks kept by the eldest daughter, age 16, which prosecutors have designated as victim journals. In one entry, read into the record during a sealed hearing that was inadvertently left open for 45 seconds before the court realized its error, the girl wrote, "Mom says the state steals kids who talk, so we don't talk. We don't open the door. We don't look out the windows. Today, I counted cars on the road. 4 passed, 1 slowed down. My heart stopped, but it kept going." That journal page is now Exhibit 64. It was not supposed to be heard by anyone outside the grand jury room, but a microphone left live on the Vinton County Court of Common Pleas livestream captured the prosecutor reading it aloud before the feed was cut. That audio, just 45 seconds of a prosecutor's voice trembling almost imperceptibly on the word heart, is now archived on the court's own public server, a ghost file that anyone can request and almost no one knows exists. And so we arrive at the current moment, a mother asking to be released on a recognizance bond because she is indigent, her poverty so extreme that her lawyer uses it as an argument for mercy. A grandfather hospitalized with an undisclosed medical condition that the county cannot afford to treat in custody because the county, Vinton County, is the least populous in Ohio, with a general fund so depleted that one catastrophic illness behind bars would indeed, as the prosecutor stated, bankrupt it.
Listen.
First, let me stress, the community is not at risk because of this bond. Yesterday, as you all know, when the cases were scheduled for preliminary hearing, during the transport, Mr. Siders fell and had a medical issue that required treatment and assessment. O'Glennis Hospital was where he was taken, and it was determined at that point upon some tests that O'Glennis did that Mr. Siders Sr. has a serious medical condition that requires specialized care in a hospital outside of this area. Practically, and I don't know if you folks know this or not, but when defendants are housed in county jails, it is the county's responsibility to pay for the medical care. Prisons are for defendants who have been convicted. Then the state pays for it. But he's still an innocent man that has not been convicted yet. So the county was going to be on the hook for his medical care. And again, based on the information that we were provided, his medical care could potentially bankrupt Vinton County. We were not going to put that burden also on our local taxpayers. And so it was agreed that we would do a recognizance bond so he could get the medical treatment that the doctors say he needs, and won't cost the county that money.
The irony is full and brutal.
I don't know at this point. We would have to determine whether that's something that the court finds appropriate. Obviously, you know, he is still technically on bond, even though he's been released. He's been given a recognizance bond with certain requirements, including a GPS monitor. When people are given a recognizance bond, they still have terms and conditions of bond they have to comply with. I don't know at this point. I think we're still in the early stages of what that might look like. It's up to the court ultimately where he can stay. As long as it's an appropriate facility, then I'm sure the court would be open to that. But the court may be thinking about, again, if he has these significant mental health issues or physical health issues, then perhaps a transitional care or a transitional.
The county could not afford to jail him, but it also could not afford to fine 16 children before a warrant for an unrelated misdemeanor finally kicked down the door. The state's poverty and the family's poverty are now mirror images, 2 photographs hung side by side in a courtroom where everyone is trying to explain how the picture developed. Endless Cryme has obtained the full warrant affidavit for the June 30th search. It is public record, available from the Vinton County Clerk of Courts, case number 2025 CR47. We want you to read it yourself, specifically the narrative section beginning at paragraph 12, where the affiant describes the moment of entry and the first observations made by law enforcement. Then answer this question in the comments. What detail in that paragraph does the indictment leave out, and why do you believe the state chose to omit it? We will read every response because our investigation is not finished, and as this case moves toward a grand jury presentment that could take months, the gaps between what is charged and what was known will only grow wider.
The Attorney General did offer assistance and has agreed to provide an assistant AG. Her name is Kara Keating, and yesterday a motion was filed to have her appointed special prosecutor to assist me in the prosecution. Also, Annika Collins, who is a Highland County prosecuting attorney, I also filed a motion to have her appointed as a special prosecutor, as she was an old colleague of mine when I worked in Highland County. Both of these women are outstanding prosecutors with extensive experience in child cases, and they will do nothing but help our team progress through these cases.
If you believe that public records are the only antidote to public neglect, then like this video, share it, subscribe to Endless Cryme, and turn on notifications. The evidence never sleeps. Neither do we.